circumstances. That is, the agent and principal. When the agent does something, the principal is liable. We facit LL.M. facit per se. That is, he who does an act through another, laws presume that as if he does that act. Similarly, there is a partners, when one of the partner is the agent or principal of another. So in such case, if a partner commits a tort, the other partner is also liable. And the third is also master servant. When a servant does something, the master is also commits a tort. The master is vicariously liable for that tort. Why? Respondent superior. That means the master is solvent enough to pay the compensation. That happens. When somebody employs another, he must choose a best person. So that's why this master servant, there must be some relationship. To make a person vicariously liable, there must be some relationship between those two persons, and if the other person commits that tort while discharging his duty on his behalf of that person. So, always to make the servant. Then who is servant? What is the test to determine who is a master and who is the servant? If a person has, that is fair and fair rule. Fair and fair rule means who is paying, who is giving the salary, and who can dismiss him, and who has a control over the work. He is to be treated as a master. The person who is in employment, normally we know he is the servant. So to make the master liable, the servant must have committed the tort during the employment, during the course of employment. It is very important. During the course of employment, sometimes the servant committed tort outside his employment. Further, in that case, the master is liable. When a servant does an act which is not in the course of master's business, the same is due when if it is not in the business of the master, then that is to be treated as if the servant committed that act outside the course of the employment. So, even though he is not strictly in the performance of the duty of the workman. For an example, if a workman driving a little away from the place of his work for his midday meal and he commits a tort, in certain cases, then it will be treated during the course of the employment. But if certain workmen who are permitted to use their master's vehicle for having refreshment, for his own refreshment, for his own pleasure, he decide go for a cab at a distance place, then that may not be during the course of the employment. So, whether the tort was committed by the servant during the course of the employment or not, that is to be considered, that is to be decided, taking into facts and circumstances of each case separately. That is, in Story versus Aston case, there a carman, while on his way back to his employer's office, was induced by another employee to turn off in another direction for picking up something for that employee. The carman, he was requested by another employee to take the car to another place to bring something for that employee. While the carman was going on his new direction, he caused an accident with the plaintiff. He caused an accident. Then the question is whether the master will be made liable vicariously for the act of the servant. So here it was held that the master was not liable because the carman had taken the car for his own pleasure. That is had been taken the car for his own purpose. So, but suppose in a roundabout way he goes, that may be during the course of the employment. The master would be liable. Suppose the carman did not come in the proper direction way, but he took a roundabout way for the work. then that will be treated as he did that work during committed that tort during the course of employment. So here, similarly, another case, State Bank of India versus Shama Devi. In this case, Shama Devi opened a savings bank account with plaintiff's predecessor, that is Imperial Bank of India, at its Allahabad branch. What happened? The respondent gave some cash and a check to one Kapil Dev Shukla, who was a friend of the respondent's husband. That is, respondent husband, he gave a check and who was employed in the said bank for being deposited. So what happened? The employee of that bank, instead of depositing that, withdrew the amount and misappropriated. Further, the State Bank will be made liable for the act of his servant. The bank servant, instead of making the deposit in the respondent's account, got the check cashed and misappropriated. So he made the false entries in the respondent's passbook and bank's ledger. It was held by the Supreme Court that the servant had acted outside the course of employment and the appellant bank could not be made liable for the fraud committed by such servant. Then another case is that Baird versus London General Omnibus Company. In this case, is a very interesting case. How always you should know whether it will be decided whether the servant committed the the alleged tort in the course of his employment. If he commits the tort outside his employment, then the master will not be liable. In Baird London General Omnibus Company case, the driver of a bus went to take his dinner. During the temporary absence of the driver, the conductor drove the bus in order to turn it around to make it ready for the next journey, and negligently caused an accident where the plaintiff was injured. It was not the conductor's duty to drive the bus. So, since the driving was not the kind of an act which the conductor was authorized to do, the conductor was acting outside the course of employment. Again, it is case to case. So, the master's liability arises only when the servant commits a tort during the course of his employment. If that is, the master's liability only when both the conditions. First, the wrongdoer is his servant, and the servant, while doing the wrongful act, was acting in the course of his employment. So, in Baird's case, the conductor who caused the accident by negligent driving was not acting in the course of his employment, as he was not been entrusted to drive the bus. Similarly, instead of the driver, a stranger drives. Suppose a stranger drives, because he is not the conductor. If a stranger would have driven the bus, the master cannot be made liable. So, this is the rule. So, first, the master is vicariously liable for the tort committed by the servant when that tort is committed by the servant during the course of his employment. Whether that tort was committed during the course of the employment of the master or not, that is to be considered, taking the facts and circumstances of each case separately. There cannot be a universal rule. What is that? So here, sometimes negligent act of the servant. Suppose negligent act of the servant, then the master will be liable. So here, suppose the servant negligently delegates his authority to another to drive the bus. Suppose the driver allowed the cleaner and you drive the bus. So for that, if an accident occurs or a tort is committed, for that this master is liable, because here that is the negligent act of the servant. In Ricketts case, Thompson Tilling case, Ricketts case is a very important case. The driver of a bus seated himself by the side of the conductor. The driver sat by the side of the conductor and permitted the conductor to drive the bus for the purpose of turning the omnibus in the right direction for the next journey. The conductor drove the bus so negligently that it mounted the pavement, knocked down the plaintiff, and seriously injured him. It was held that the master was liable for the negligence on the part of because driver himself sat by the side of the conductor, and because of his negligence, the conductor drove the bus and caused the accident. For that, the master will be liable. You cannot say here this cannot be treated as if that the act thought was committed by this servant not during the course of his employment. That is, during the course of his employment as a driver, because of his negligence, the conductor drove the bus and got the accident. So in Ricketts case can be distinguished from Bates case. So we should understand Bates case. What is that Bates case? The driver was absent. There the driver was absent. The conductor drove the bus and caused the accident. So that it was held that was outside the employment of the servant. So here, but in Ricketts case, the driver was present. He negligently authorized the conductor to drive the bus and thereby the conductor caused the accident. For that, it was held that was during the course of employment and the master is liable. In Baldev versus Downey case, the driver of a truck sat by the side of the conductor and allowed the conductor to drive. The conductor caused an accident with a rickshaw, as a result of which rickshaw passenger died. It was held the act of the driving by permitting the conductor to drive the vehicle at the relevant time was a breach of duty of the driver, and that is negligent act of the driver. For that, the master will be liable. In Indian Insurance Company versus Radhabai, it is another case. The driver of a motor vehicle belonging to state government who was asked to bring ailing children to the primary health center gave control of the steering wheel to an unauthorized person. The driver of that is a ambulance allowed another person to drive the bus, and soon thereafter there was an accident. It was held that the master that the government was liable for unauthorized act of the driver. In Garci Devi versus Saindas, the driver of a truck which was loaded with stores had a duty to unload it at a certain place. The driver went to his house and instructed the cleaner, you take the truck and load there. And the cleaner drove the truck and caused an accident. For that, the master is liable. Because due to negligent act of the servant, if this tort was committed. So in Ilqui versus Samuel case, the lorry driver employed by the defendant permitted a stranger to drive the lorry. While the stranger was driving the lorry negligently, an accident was caused. So here, that was during the employment, because the driver's negligence. Because of the driver's negligence, an outsider drove the truck and caused the accident. In William versus Twitch case, the driver of an omnibus being suspected to be drunk was, here it is a very important, interesting case. Driver of a omnibus was a drunk. The police did not allow that driver to, or the conductor, they discontinued the driver to drive and allowed asked another person to drive the bus. And he caused the accident. So whether, in such case, the master will be liable. It is very interesting. The driver and the conductor of the omnibus authorized a stranger who happened to be standing nearby to drive the bus. The negligence of the stranger resulted in accident causing injuries to the plaintiff. In an action against the master, it was held that this situation did not give any implied authority to the servant to delegate its authority. Because of the direction of the police, another person drove the bus. So here, Gilwan case, the question of master's liability on account of servant negligence delegating the authority was not discussed. In this case, it was not discussed. If the question had been raised, the decision would have been otherwise. That is negligent. That is, he was negligent, the conductor and driver. In Kilari, Mani versus Bariwama Chemicals case, the driver of a jeep left the ignition key in the jeep and went to the tailor shop. So this provided a chance to B to drive the jeep and cause the accident. So here the negligence. So that is during the course of employment. So in Englarat versus Farran case, the master was made liable for the servant such negligence. There the driver of cart had been given instruction not to leave the cart. That is a cart unattended. He, however, left the cart in the care of a boy who was ignorant of the driving the cart, in the absence of the driver, the boy tried to turn down the cart, and while doing so, he ran into the plaintiff's carriage. It was held that though the boy negligent driving was not in course of employment, but the negligence of the driver allowed the boy to drive the cart. That is, so for that the master is liable. In Sitaram versus Santanu Prasad, another case, the Supreme Court, that the master be made liable if his driver lends the taxi to third person for a private use. Whether a person, driver allows a taxi to drive the taxi for another person's private purpose. The fact of the case is, Sitaram, who was the owner of a car, entrusted the same to one Muhammad Yaqub for plying it as a taxi in Ahmedabad. Muhammad Yaqub, who was in sole charge of the taxi, Yaqub employed a cleaner. He trained the cleaner in driving the taxi. So here on April 11, 1940, he gave the taxi to the cleaner for taking the driving test and obtaining the driving license. While taking the test, the cleaner took a sudden turn without giving any signal, caused an accident and seriously injured the plaintiff's leg. The question was whether the Sitaram will be liable as the master. So here it was held that what is held? That the owner had either permitted, because it is not outside, that is during the course of employment, because the owner had never permitted that person to lend that car to another person to drive or take the driving test. The cleaner at the time of the accident was not doing the master's work, so it was not allowed. But the Supreme Court in Sitaram case distinguished the case before it, Ricketts case. So that is that is a very important case you should know. First, whether during the course of employment or not. Suppose sometimes the master has given express instruction to the servant not to do the particular act in a particular manner. Not to do. Suppose a owner of a car had instructed driver not to lift any stranger. But violating that instruction, he lifted a stranger, gave lift of a stranger, and that the stranger died in an accident. Who will be responsible? Sometimes the employer forbids his servant from doing certain acts. That is called express prohibition. Employer had expressly prohibited the servant to do a particular act. It does not necessarily follow that an act done in defiance of the prohibition is outside. Suppose because there is some express prohibition has been given, or it has been informed to the servant prohibiting to do something. If in spite of that, if the servant did some act and thereby causes injury somebody and a tort is committed, then also the master will be liable. In Limpus versus London General Omnibus Company, the defendant driver, in defiance of the express instruction not to race with or cause obstruction to other omnibus, tried to obstruct a rival omnibus and thereby cause an accident. So the driver had been engaged to drive and his act was a negligent. So that will be a negligent act, mode of driving, and it was held to be within the course of employment. Even if the master has given specific instruction to the servant not to do a particular act in a particular manner or not to do a particular act, if the servant violates that instruction and thereby commits a tort, for that the master will be held liable, that is vicariously. The very interesting case is, you should know, giving lift to an unauthorized third party. Sometimes a lift is given. So it was held that Twain versus Baines expressly that the act of giving lift by a driver to an unauthorized person, in that case, fell outside the course of employment. If the driver gives somebody as lift, unauthorized lift, then the position regarding lift to strangers as emerging out of various decided cases. So there are there, but in India, the trend of decision of various high court in India appears to have discarded the approach of the decision, that is Twain versus Conway case. What is that case? If a lift has given, so that is also to be treated as course of employment. The Gujarat High Court did not, in one case, Conway's case did not allow compensation, but the other high courts, they have also held that giving lift to an unauthorized person was the performance of the act totally outside the course of the employment, and the master was not liable for the consequence of giving such lift. The High Court have subsequently overruled the decision. Again, there are many decisions. Again, that was overruled. It told that the act of servant employed to drive a vehicle from one place to another, giving leave to a person in disregard of statutory rule or provision while driving the vehicle in exercise owner's is an act for the owner is vehicle, because that will be treated as negligent act. For that, that is liable. Suppose this is left. So now, doctrine of common employment. What is doctrine of common employment? Suppose I have employed 2 to 3 persons in my work. Due to act of another employee sustained certain injury. Further, for that, I am liable. This is called doctrine of common employment. While some servants are doing particular act in common, if due to negligent act of one of the employee, another employee sustains certain injury. Further, for that, the master will be liable. The rule known as the doctrine of common employment was an exception to the rule that the master is liable for the wrong of his servant committed in the course of his employment. It is an exception rule, because the rule was first applied in 1837 in England, but now the position has been changed. That is doctrine of common employment. That is Employees Liability Act of 1880, and that was passed in England. And in such case, compulsory will be certain cases the workman giving compensation to the workman. Doctrine was supposed to be based upon the implied contract. Why? That when some person they do service, that the servant agreed to run the risk. When there is risk in unemployment, others, those persons who are working together, they have impliedly agreed to run the risk. If the harm was caused by the employer's own negligence, but when employer's negligence was there, the employee could recover. Only the employee's claim was defeated because of the contributor negligence. If a contributor, the employee is himself negligence, that will be treated as contributor negligence. Mere knowledge of the risk by the workman was, however, no defense. Suppose if X was injured by the negligence of A's servant, and X himself also happened to be A's servant, X could not recover that from A. If X himself was not A's servant, he could successfully bring an action against him. Both are servant. One servant sustained injury, he cannot recover the damages, that the compensation from the employer. The doctrine was that is unjust doctrine, but the doctrine was criticized, and again the employees that was legislation, and in the scope of legislation and judicial decision, and eventually this is abolished. It was abolished in England in the year 1940s. The doctrine of common employment, that was on that ground the employer was not liable, that was abolished in the year 1948. The Employees Liability Act 1880 provided for compensation only to certain class of workmen in certain cases. Then again there was change in 1946. National Industry Injuries Act was passed. The act provided England. I am telling about England, that the insurance to all persons employed under the control of the service of apprentices. So now insurance coverage is there. But in India, the matter came for discussion in a number of cases. In Secretary of State versus Rukmini Bai, the plaintiff's husband and employee, plaintiff husband and employee This is doctrine of common employment. So now, in nutshell, so that is not applicable in India. Due to adverse change, now this employer is made liable. for the act. Now, another very important is vicarious liability of the state. You know, state is the what? A biggest employer. Many employment in the recent times are under the state. If the employee of a state or a servant of a state commits a tort, whether the state can claim immunity or claim is this exemption of damages or this immunity to pay the damages on the ground of sovereign act. So you know, a state act of state is a defense in tort. Act of state means that is statutory authority or a sovereign act. So how far the state is vicariously liable for its employee, let us discuss. So in England, the crown at common the crown could not be sued in tort. That was the previous law in England, that the crown was not allowed to be sued in tort. What? For wrong actually authorized by it or committed by its servants. In England, crown was not to be sued for tort, either for the wrong actually authorized by it or committed by its servant in the course of their employment. No action could lie against the head of the department or other superiors for the act of their subordinates. In England, that was the law. The individual wrongdoer was only liable. Suppose one servant was an employee of a state, was committing a tort. For that, the state was not made liable, but that particular employee was liable. This immunity of the crown from liability did not exempt the servant from liability. This immunity was there for the crown, but the servant, if he was committing a tort, for that he was liable. The result was that whereas an ordinary master was liable vicariously for the wrongdoer, but the state being the master was not liable. So, with the increase of functions of the state, the crown became one of the largest employers of labor in the country due to the increase of various functions. Nowadays, the crown or state is the largest employers of labor in country. So in most of the time, an employee of a state commits a tort. Under these circumstances, the rule of immunity for the crown became highly incompatible with the demands of justice. So when the crown was made, the immunity was given to the crown, there was injustice. To overcome the shortcomings of the prevailing law and to ensure justice, various devices were found out. Again, the crown started the practice of defending action brought against its servant in respect of committed by them in the course of their employment. So, judgments against the crown servants in such cases were satisfied as a matter of guess, but then law was changed. So, this law was changed, that is, in Royster versus Cavi, it was held that it was necessary for a case to succeed, the person named by the Treasury Solicitor should be the same who was apparently a wrongdoer. The position was entirely changed after the Crown Proceedings Act 1947, that is in England. So now, after passing of that act, Crown is liable for the tort committed by its servants. So you should know. So in England, the Crown was not liable for the tort committed by its employee or servant. But that was injustice. Again, law was changed. That is Crown's Proceeding Act 1947. As per that act, the Crown was made liable under the tort committed by its servant, just like a private individual. Section 2 of that Crown Proceeding Act 1947 provides that, subject to the provision of the Act, the Crown shall be subject to all those liabilities in tort, which, if it were person of full age and capacity, it would be subject. In respect of torts committed by his servants or agents, in respect of any breach of those duties which a person owes to his servant or agents at common law by reason of being their employer in respect of any breach of the duties attaching a common law to the ownership, occupation, possession or control of property. That means for the first time, this due to Crown Proceeding Act 1947, the state was treated like an individual in when there is a suit for a suit was filed for claiming damages on the tort. In India, what is the position? In India, you see, unlike the Crown Proceeding Act 1947, we have an Article 300 of the Constitution of India. What Article 300 of the Constitution of India provides? That the state can sue and can be sued. What it says? But in this Article 300 of Constitution of India says the government of India may sue and be sued by the name of Union of India, and the government of a state may sue or be sued in the name of that state, and subject to any provision which may be made by Parliament or of the legislature of such state enacted by virtue or power conferred by this concern, sue or be sued in relation to their respective affairs in the like cases at the dominion of India, and the corresponding provision or the corresponding Indian states might have sued or been sued if the constitution had been enacted. So if at the comments of the concern, so that is the Article 300. So now the state is responsible. State can be sued for tort committed by this state, but only if a tort is committed by the employee so while discharging its sovereign power, then in such case the state is not liable. So in this case, an important case in this context is Peninsular and Oriented Steam Navigation Company versus Secretary of India. What in this case? The plaintiff servant, it is this first case in India, that is Peninsular and Oriental Steam Navigation Company, Secretary of State for India, that is during East India Company. In that case, the plaintiff servant was traveling in a horse-driven carriage and was passing by the Kiderpur dockyard in Calcutta. Traveling horse-driven carriage was passing by the Kiderpur dockyard, which is the government property. That was the government property. Due to negligence on the part of the defendant servant, a heavy piece of iron, which they were carrying for the repair of a steamer, fell and its clang frightened the horse. The horse rushed forward against the iron and was injured. The plaintiff filed a suit against the Secretary of State of India in counsel for the damage which was caused due to the negligence of the servant employed by the government, that is East India Company. The court tried to look the liability of East India Company. Then the court decided whether the East India Company. A distinction was drawn between the sovereign and non-sovereign function of the Indian company. It was held that if the act was done in the exercise of sovereign function, the East India Company would not be liable. But if the function was not the sovereign one, which could have been performed by a private individual without any delegation of power by the government, the company would have been liable. So maintenance of the dockyard was considered to be a non-sovereign function, and as such, the government was made liable. This is the first case, that is Peninsular and Oriental State Navigation Company versus Secretary of State Union. In Navin Chandra De versus Secretary of State for India, the state was exempt from liability when the function was considered to be a sovereign one. Then the second one, Navin Chandra De versus Secretary of State, then it was held that the state is not liable under the tort when the tort was committed while is exercising the sovereign power. There the plaintiff filed a suit contending that the government had made a contract with him for the issue of license for the ganja and had made breach of the same. On evidence, it was held that there was no contract. Relying on this Peninsular and Oriental Steam Navigation case, it was further held that, assuming that there was a contract, the action could not lie as the work was done in the sovereign power. Giving license is a sovereign power. Similarly, on the authorities for this point, again, the Secretary of State for India, Council and Haribanjab, where the position was explained. The Act of State, of which the municipal courts of British India are debarred from taking cognizance, are acts on the exercise of state. If a particular act of the state, these municipal courts are debarred to take cognizance, in such that will be treated as sovereign power. Where an act complained of is the professional done under the sanction of municipal law, and in the exercise part conferred by that law, the fact that it is done by sovereign power. So, P.B. Rao versus Khushal Das case. The requisition order passed by the province of Bombay was challenged, but in defense it was ordered that no action can lie against the province of Bombay in respect to act done in exercise of the sovereign power. That is, Bombay, that in this case, Vidyavati versus Lokumal, the plaintiff's husband died after being knocked down by a government jeep car, which was driven rashly and negligently by an employee of the state of Rajasthan. In this case, at the time of the accident, the car was being taken from the workshop to the collector's bungalow from the collector's use. In an action against the state of Rajasthan, the state was held liable because that was not a sovereign act. But very interesting case is Kasturi Lal case. You should remember. This is a gold appropriated by a constable. What is this? What is the Kasturi Lal case? That. Another case is that state of Rajasthan versus Bidwati. In that case, the observation made by the Supreme Court may also be noted in this connection. It has been remembered that under the Constitution, so if establish a welfare state, so whose functions are not confined only to maintaining law and order, but extend to engaging all activities, including maintaining law and order. So if the state trading, only a few of them, insofar as the state activities have wide power, involving not only the use of sovereign power, but also other power, welfare measures. So here, this is liable, state is liable for any accident which was caused due to by a servant, if it is not while exercising sovereign power. So here, in this Vidyavati's case, the position is not very certain or satisfactory. The Supreme Court in the case of Kasturi Lal, so in Kasturi Lal case, what has happened? In this case, Kasturi Lal case, again stated, Kasturi Lal case, Ralia Ram, one of the partners of a firm of jewelers, Kasturi Lal Ralia Ram, at Ambusa happened to go to Meerut, reaching there on the midnight. In this case, while he was passing through one of the markets with the belongings, he was taken into custody of the police, and on search, it was found that he had been carrying 103 tolas of gold and 2 over mounds of silver. He was kept in police lockup, and his belongings were also kept there. Next day, he was released on bail, and sometime thereafter, the silver was returned to him. The gold had been kept in the police malkhana under the charge of the then head constable Muhammad Amir. The head constable misappropriated the gold and fled to Pakistan. So the plaintiff brought an action against the state of people claiming the gold ornament. The state was held to be not liable under the law of tort, and that was a sovereign act, sovereign function. The police officials were acting in discharge of sovereign power, statutory power, and the power of the police official in keeping the property in the police malkhana was a sovereign power. This Kasturi Lal case is a milestone in the case. So this is, but now what is sovereign power and what is non-sovereign function? That is to be seen in each and every case. In Headmistress Government Girls High School versus Mahalakshmi, the Aya, who was a servant of a government, managed girls' school as a girl student of 9th standard to bring water on a cycle carrier for school children, which was otherwise the duty of the Aya herself. The spring from the cycle carrier suddenly came up and hit the girl in her right eye, and she lost the eye. For this fault, Aya, that is the government servant, the negligent delegate authority state running the school, was held vicariously liable, because it is not a sovereign function. A.H. Khadwa versus State of Maharashtra also, the doctor of a government hospital, while performing sterilization operation of a lady patient, left a mop inside the abdomen of the patient. As a consequence, that developed that there was the death of that woman. That is, so here the government was made liable vicariously. But when a police officer's act is there. It is very important. When a police officer does some act, whether that will be a tort is committed, whether that is sovereign power. So in the state of Odisha versus Padmalochon, it is a leading case in the matter, which had arisen was whether the excess committed by the police person while discharging their duties could come within the purview of delegated sovereign function, so as to exempt the state from the liability. What in this case, what happened? The fact of the case are that there was an apprehension of an attack on the office of the SDO. There was an apprehension of and its properties by the mob, which had resorted to violence there. The Odisha military police, under the control of the supervising officer and a magistrate, cordoned the area. Some police persons assaulted members of the mob without order from the magistrate. So here, as a result of which the plaintiff was injured, action was brought under the law of tort. It was held that the posting of police personnel for cordoning in front of SDO court was in exercise of delegated sovereign function. So in such case, the state will not be made liable. Another case in state of Assam versus MT Nizamuddin, the plaintiff was carrying on business in sale of seeds of different agricultural products such as jute, vegetable, oilseed. The business was being carried on without a license, which was needed for such business. The police authorities seized the seeds from the plaintiff's shop. The seed got damaged because of lack of storage facility and the negligence while they were in police custody. The plaintiff claimed compensation from the state for the damage caused to the seeds while in police custody. It was held that the seizure of the seed was in the exercise of sovereign power, and the plaintiff was therefore not entitled to claim in damages for this. Even while I was discharging my duties as a civil judge senior division at Bolangir. Similar claim was made for seizure of some compensation for seizure of some food grain because of due to want of license, and that was damaged. I had applied this, that is the sovereign power. The Madhya Pradesh High Court made a similar decision in state of MP versus Chiranjit Lal. In that case, the police made a lathi charge on a student procession. When the same became unruly, the loudspeaker set belonging to the plaintiff, which was being used by the students in their possession, got damaged. In an action for the owner of the loudspeaker against the state to recover compensation, it was held that maintaining law and order is the sovereign power. So here, if while exercising sovereign power, if any tort is committed, then suppose in military servants, although the maintenance of the army is a sovereign function, but this does not necessarily mean that the state will be immune from liability for any tortious committed by the army. A distinction has to be drawn between the acts which could be done by government in exercise sovereign power and which can be done with not exercise. In this case, liability for illegal acts. Suppose the military persons they commit some illegal acts. Principle of vicarious liability for illegal acts committed by armed personnel has been invoked under the public law domain. What is case? In case Srimati Meenam Ungvi Bina Devi versus State of Manipur, rape was committed by an employee of the Union of India, though the accused employee had been not on duty but on unauthorized leave. The accused under role of the Assam Rifle while being posted in Manipur was deemed to be the active service not only within the meaning of the Army Act but other law. So here in his case, holding the central vicarious liable for the offence of rape committed by the accused, because that is, it will not be treated as a sovereign act. The tort was not committed while exercising sovereign power. So act done in exercise of sovereign power, there are various acts. Secretary of State versus Cochrane, it has been held that maintenance of a military road is a sovereign function and the government is not liable for negligence of its servant in stacking of gravel on a road which resulted in carriage accident. In Union of India versus Urban Sea, meals were being carried from the cantonment Delhi for being distributed to military personnel on duty. The truck carrying meals belonged to the military department and was being driven by a military driver. It caused an accident resulting in the death of the person. It was held that the act was being done in exercise of sovereign power. In Boxi, Amrik Singh, there was an accident between a military truck and a car on the Mal Road in Ambala. Due to negligent and rash driving the truck driver, Sipai Mansingh, who was also an army employee, Amrik Singh, an occupant of the car, received seriously. subsequently he brought an action against the Union of India to recover compensation. The Union of India, apart from claiming that was a no fault part of the military driver, aborted that it was a sovereign, exercising the sovereign power. So, Union government, that is, the Punjab Iron, after discussing the detail, the various authorities on the point, came to the conclusion that the checking of the army personnel on duty was a function intimately connected with the army discipline and could only be performed by a member of the armed force, and that too by such a member of that force who is detained on such duty and is empowered to discharge. It was therefore held that since the military driver was acting in discharge of a sovereign function of the state, the Union of India was not liable. So acts done in exercise of non-sovereign power, so the state will be made. In Satyavati Devi versus Union of India, the Air Force personnel constituting hockey and basketball team were carried by an Air Force vehicle, and due to negligence of the driver, death was caused of the plaintiff's husband. Then this was treated as non-sovereign power exercised. So in India, tort committed while performing duty in discharge of obligation imposed by law has been considered to be a defense in India. Even exercising a discharging an obligation on the law, that will be treated as a defense in India. So there are various case laws in the matter. At least you should know how far when the state is not liable for the tort under the tort while exercising its sovereign power, suppressing riot. It has been held that in order to succeed in the claim of damages caused to the property of a person, has to establish that by such damage the right to livelihood has been infringed. This law has settled by in Kasturi case that a police officer misappropriating the seized property, that will be treated as the sovereign power that has been changed through a number of decisions in the Supreme Court. Should the courts in India follow Kasturi or subsequent decision of the Supreme Court? It is interesting to note that in many of the cases, the Supreme Court has granted compensation as an ancillary relief while exercising its jurisdiction under Article 32 of the Constitution. The Supreme Court has not only itself granted compensation as an interim measure, but has also expressly stated that the same is granted without prejudicing the right of petitioner to claim just compensation. So now, Kasturi case is not, that has been, that is, in the Supreme Court has expressed dissatisfaction of the prevailing position of Kasturi case. Honorable Justice, Chief Justice Gandharv. That is now, in most of the cases, that is, in its past, that is, this Kasturi case is practically, it has been overruled. In Nagendra case, the Supreme Court considered the question of vicarious liability of the government for the negligence of its servant. It noted the earlier Supreme Court decision in Vidyavati and Kasturi case, recommendation of the Law Commission in the first report for statutory recognition of the liability of the state as a head, as had been done in the England. So now, most of the state is also against that. Thank you. In the next class, we will discuss what is the remoteness of damage.